Boris Johnson is prepared to take legal action in an attempt to ensure the UK leaves the EU with no deal this month. The Prime Minister is reportedly willing to take his Brexit battle all the way to the Supreme Court in order to avoid asking for an extension to Article 50. The move would allow Mr. Johnson to avoid having to write a letter asking as set out in the Benn Act recently passed by MPs recently. Several senior government sources told the Daily Telegraph that the Prime Minister was more than willing to go to the Supreme Court to fight his case despite the Benn bill. The news raises the possibility that Mr. Johnson could give evidence in a bid in order to persuade judges in person against forcing him to ask the EU for a delay to Brexit. Adding to the severity of the situation, a senior government source said it was vital that Mr. Johnson was forced to write the letter delaying Brexit rather than agreeing to do so voluntarily. The source said Number 10 needed to find a legal mechanism in order to allow the Prime Minister to at least say 5 days before the 31st of October, "I am literally not going to write that letter." The source added, "The real drama would be if Boris were in court calling it the Surrender Act. He would almost be happy if the judge said you can't call it that." The decision to take legal action comes 2 weeks after justices at the Supreme Court ruled unanimously that Mr. Johnson's decision to prorogue Parliament was unlawful. The Prime Minister is attempting to use every means possible to avoid following the Benn Act, officially named the EU Withdrawal No. 2 Act, which legally requires him to ask the EU for an extension on Brexit if the UK does not reach a deal with the EU by the 19th of October. Former Tory Prime Minister John Major has suggested Mr. Johnson could consider an order of council to override the act. Attempting to do this would lead to uncharted legal territory, which some have questioned whether it would even be allowed. Yesterday, the Court of Session in Scotland met to rule on what kind of sanctions would apply if ministers fail to comply with the Benn legislation. The court had previously been told that the UK government can't be trusted to comply with a law aimed at avoiding a no-deal Brexit. Prior to the case, businessman Dale Vince, QC Joe Mormond SNP MP Joanna Cherry asked the judge to set out the penalty for non-compliance with the act. Despite fears, a document submitted by the UK government confirmed it would write a letter requesting a delay if no deal is agreed by the 19th of October. The letter seemingly contrasted with Mr. Johnson's repeated claim that the UK will leave the EU on the 31st of October, with or without a deal. Confusion was furthered when on Sunday, Stephen Barclay, the Brexit secretary, refused 3 times to confirm whether Mr. Johnson would write the letter required of him. Instead, Mr. Barclay insisted that the government will abide by the law. A return to the Supreme Court would see Mr. Johnson's government at the mercy of Supreme Court judges for a second time. One judge's impartiality, Lady Hale, was called into question over the weekend after she was filmed mocking Mr. Johnson's defeat to the court. She also made reference to his girly swat remarks to describe his predecessor David Cameron. The government's lawyer, Andrew Webster QC, told the court it could not be clear that Mr. Johnson's government intended to comply with the law. Mr. Webster argued that there was no need for the Prime Minister to be forced into writing a letter, because the court had it on record that it would be done. Asked by Judge Lord Peatland why the government would not make written undertakings under oath to quell the concerns of petitioners, Mr. Webster said this was not necessary.